2013, 255, 2013, 322. State of Arkansas versus Matthew Johnston. Mr. Johnston, you're appearing at this time for purposes of changing your plea on the charges in both of these cases. Is that correct?
Yes, Your Honor.
And this plea change is brought about by an agreement that's been worked out for you by your attorney, Mr. Friend?
Yes, Your Honor.
And have you discussed the terms of the agreement and the punishment you're to receive with Mr. Friend?
Probation and payments, correct?
All right.
Yes, Your Honor.
Well, have you discussed it with him, and do you feel you understand what it is?
Yes, sir.
All right. Are you satisfied with the advice and the representation you've received from Mr. Friend?
Yes, sir.
On the charges, in case 2013-255, where you're charged with commercial burglary, a Class C felony, and theft of property, a Class B felony, and in case 2013-322, where you're charged with theft of property, a Class D felony, and breaking or entering a separate Class D felony, how do you now plead in each of these cases?
Guilty.
You're in this plea of guilty pursuant to the agreement we were discussing, and that agreement is set out in writing in these documents I'm holding up called plea statements.
Yes,
Have
sir.
you read over both of these plea statements and signed them?
Yes, sir.
And do you feel you understand what's contained in them?
Yes, sir.
You then understand the nature of the charges against you and the full range of penalties you're facing?
Yes, sir.
You understand the rights that you give up or surrender by pleading guilty?
I'll just be having to go by the conditions that are within that paperwork and face a probation officer, correct, sir?
That's right. What is in this plea statement is it explains that you will be, by pleading guilty, you're giving up your right to a jury trial.
Yes, sir.
You're giving up your right to be represented by an attorney and have the assistance of that attorney throughout the trial process. You're giving up your right to confront the witnesses that would appear and testify against you at trial, and you're giving up the right to appeal. You understand these rights you're giving up by pleading guilty?
Yes, sir.
And understanding what you're giving up, are you still willing to enter this plea of guilty?
Yes, sir.
Are you pleading guilty here today freely and voluntarily?
Yes, sir.
Has anybody in any form or fashion forced you into entering this plea of guilty?
No, sir.
As you plead guilty here today, do you acknowledge that on or about the 10th of July, 2013, you participated in breaking into the Johnson Jewelry Store here in Mountain Home, and that you took from that the premises property valued apparently somewhere between $50,000 and $100,000.
Yes, sir. Upon that contract, yes, sir, I am pleading guilty based on those conditions.
I understand this is all based on these plea agreements. We've already been over that.
If he ain't happy, he'll be happy since he's asked the pen. Yes, sir. Matthew.
Yes, sir.
Okay. My question to you is, did you do the crime?
Upon what I've said, yes, sir. The parts that I've stated with my lawyer, yes, sir.
All right. In case 2013-322, do you acknowledge that on or about or between the period of July and September of 2013 here in Baxter County, you entered into another person's mini storage and took from various lockers property apparently valued in excess of $1,000.
Yes, sir.
Based on those statements, the court at this time accepts the defendant's plea of guilty, finding that the pleas of guilty have been entered freely and voluntarily, and that after consultation with an attorney, and that they are being entered here today, and the defendant has admitted to his participation in each of the crimes. On that basis, the court will, at this time, formally accept the defendant's plea of guilty, and in case 2013-255, the court finds the defendant guilty of theft of property, Class B felony, and commercial burglary, a separate Class C felony, and on those cases, adjudges him guilty. The court is sentencing the defendant in accordance with the agreement to 9 years of supervised probation on each of those two cases, two felony counts, subject to the standard terms and conditions of probation of this court. The court is also imposing, in this case, court costs in the amount of $200, a fine of $1,000, statutory DNA fine of $250, booking administration fee of $20, and restitution to be paid in the amount of $55,307.50 with an initial upfront payment of $8,500. This amount of restitution that's set out is a 1/2 share of the total amount of restitution due in the case, and the court is advising the defendant that technically under the law he will be liable for the full amount of restitution should his co-defendant fail to pay his appropriate share.
And that's $200 a month, correct?
We're getting there, sir. Let's go through it a step at a time. Let me ask you the questions, and I'll set out the terms of it. All of these amounts that are due and payable are payable under the terms of this agreement at a minimum payment of $100 per month, payable as a term and condition of probation through the sheriff's office. That's in case 2013-255. In case 2013-322, the court is also accepting the defendant's plea of guilty based on the finding that the defendant has freely and voluntarily entered the plea of guilty, done so after consulting an attorney, and has admitted to the facts in this case. On that basis, the court finds the defendant guilty of theft of property, a Class D felony, and breaking or entering a separate Class D felony. In these cases, the court, having accepted the defendant's plea of guilty, will find that it will impose the sentence as set out in the written plea statement of 6 years on supervised probation, subject to the standard terms and conditions of probation of this court. The 6-year sentence will run, in these cases, will run concurrent with each other and concurrent with the sentences imposed in 2013-255. The defendant is ordered also to pay court costs in the amount of $200, a fine of $1,000, the statutory DNA fine of $250, booking administration fee of $20, and is ordering the payment of restitution, in that case in the amount of $1,350. Again, these payments will be due and payable as a term and condition of the defendant's probation, payable at a minimum rate of $100 per month beginning within 30 days of this date, and that'll be the payment. In this case, the court is specifically designating that the defendant will pay $200 a month between these two cases in order to advance the payments after the initial upfront $8,500. That'll be the sentence of the court. The court is reviewing at this time the written terms and conditions of probation, which are attached to the plea statements, and signing them. When the court signs them, that makes that an order of this court that the defendant comply with the written terms and conditions that the court has ordered. The thing I want to emphasize to you, Mr. Johnston, is that you now are under the obligation not only to make the payments as stated, but also to comply with all the written terms and conditions of probation. The court has now signed these written terms and conditions. It may give them an order, but I also note that for the record that you've acknowledged by signing the acknowledgement that you have read, understand, and will comply with the terms and conditions of probation. It's all in writing. Nobody's tried to trick you in this matter. And what I'm telling you right now is that I'm going to direct at this time that you meet with the probation officer and get set up on probation. What you need to do is make sure you read that written terms and conditions of probation and understand that you are now obligated to fully comply with them. Any non-compliance can result in your being brought back in here and face, among other things, if it's established that you violated them, actually being sent to the penitentiary. But it'll only be after a hearing on the basis of your non-compliance with the requirements of probation. So it really behooves you to make sure you thoroughly understand those, because you're going to be held accountable after today. You'll meet with the probation officer at this time.